Thank you very much, Rosalind, and thank you for asking me to chair this event, which I'm really looking forward to. I'm looking forward to hearing everything the authors have to say. So just for your information, if you have questions, and I hope there'll be plenty of them, please can you type them into the Q&A section as we go along? And if there's any pressing ones, I'll direct them directly to the author in relation to clarification, but otherwise we'll just address them when we come to the end of the session. The speakers will be speaking for a maximum of 10 minutes each. So hopefully that will leave enough time, even though we have a very strict hour limit for this particular session. If there are outstanding questions that haven't been answered during the session, we will address them afterwards, and this webinar will be published on the CSA website. So without any further ado, I will just introduce each speaker just before they speak. So first we're going to hear from Lisa Claire Whitten on the theme of common frameworks. Lisa is a researcher at the Centre for Inclusive Trade Policy and a research fellow at Queen's University Belfast. And her research, which is wide-ranging and well published and highly respected, is on the trade and regulatory impacts of the UK's exit from the European Union generally, and in particular in relation to Northern Ireland. So without further ado, Lisa, over to you.
Thank you so much, Katie, and thanks all for being here. This has been a really great and interesting project to be involved in, and it's a pleasure to be launching it today. So, as Katie said, I'm going to present on common frameworks, and I'm going to just give a little bit of context on common frameworks, a little bit of context on the Retained EU Law Act, and then discuss their interaction. And this is really just a run-through sort of trailer for the paper, which I would recommend that you guys read if you have the time. So common frameworks, I presume you're all relatively familiar, but these are co-designed mechanisms by which the governments of the UK can agree some amount of regulatory consistency while also enabling differentiation in areas of policy that were previously governed by EU laws and which are within devolved competence in one or more territory of the UK. These common frameworks are sector specific, and they've been developed jointly between the UK government and the devolved administrations. Most of them have not yet been formally finalised, and we'll get on to that. So the paper outlines the origins and operation of the common frameworks process, including the principles on which it was based and which were agreed between the four UK governments in 2017. Crucially, the common frameworks process has been collaborative and based on agreed principles, which sets it apart somewhat from other strategies to deal with the regulatory effects of EU exit domestically, as I'm sure other colleagues will touch on. So key to determining the scope of the common frameworks was work undertaken in the early phases of the process to first identify areas of law where EU competence intersected devolved competence, and secondly, to determine which of those areas of intersection between EU and devolved competence would require a non-legislative common framework to mitigate against damaging regulatory divergence and to strengthen the operation of the internal market of the UK. So that scoping exercise found 152 areas where EU competence and devolved competence were intersecting. 120 of those were classified as no common framework would be required. 29 were classified that a non-legislative common framework would be required, and 3 where new legislation would be introduced, but also that would be accompanied by a non-legislative common framework. Of those 32 areas then that were the focus for the development of a common framework, one of those frameworks has been finalised, 27 have been provisionally published, and 4 have not yet been published. Colleagues will no doubt, that's your intro to common frameworks. We're now doing intro to the Retained EU Law Act, and colleagues will no doubt revise key aspects here. And I presume if you're here, you're probably also familiar with this, perhaps more than you'd like to be. But suffice to say, the overarching purpose of the Retained EU Law Act was to change the legal status of and provisions relating to the category of domestic law that was the legacy of the UK's EU membership, known initially as Retained EU Law, and which was the result of essentially a copy and paste exercise provided for under the EU Withdrawal Act 2018. To that end, the Retained EU Law Act provided for the revocation of 587 instruments of Retained EU law. It also removed all directly effective EU law, so rights and obligations conferred by EU treaties and directives in domestic law, as well as removing the domestic UK version of EU general principles, including supremacy, that had been copied across under the 2018 Act. The Act also renamed retained EU law as assimilated law, newly permitted UK courts to depart from the legacy of CJEU case law, and empowered UK ministers until June 2026 to restate, replicate, or revoke or replace assimilated law, but with a restriction that any replacement instrument could not create new delegated powers, criminal offences, monetary policies, new taxes, new public bodies, nor, most significantly, could the overall regulatory burden be increased through any relevant change to this category of law. UK ministers were also empowered to update assimilated law in light of technological developments, and there's no limit on that power. So taken together, the Retained EU Law Act and the reforms it introduced constitute a bit of a paradigm shift in the post-Brexit legal and regulatory environment of the UK by removing those general principles of moderated EU law, including supremacy, and at the same time requiring any changes to what is now assimilated law made under the Retained EU Law Act to be deregulatory in nature. This legislation has the potential to set a deregulatory trajectory for the development of significant subsection of UK policy. Now, to sort of look at the Retained EU Law Act and Common Frameworks together. So to state the absolute obvious, the Common Frameworks process was started prior to the introduction of the Retained EU Law Act. That fact is actually quite key in understanding the impact of the Retained EU Law Act on common frameworks, because a series of assessments made in the early stages of the Common Frameworks process appear to have assumed the existence of retained EU law as a category of domestic law, and one that was by definition under the initial 2018 Act infused with a relative stability due to the continued application of UK versions of EU law general principles, including supremacy. But by removing that special status of what is now assimilated law and empowering UK ministers to amend it with relative ease and limited scrutiny, the Retained EU Law Act doesn't necessarily undermine common frameworks where they've been developed in the 32 areas, but it doesn't call into question their efficacy. And I'll just very quickly note the two different ways that this intersection happens. So we have direct impacts on the operation of the provisional and finalised common frameworks in the 32 areas identified to develop a common framework. And then there are indirect impacts on policy areas where it was deemed no common framework was necessary during those initial early mapping stages. On the direct impacts on the 32 areas, so of the 28 published common frameworks that we have, in setting out the scope, each of them sets out the scope of the framework in legislative terms. And of course, in view of the purpose of these frameworks, the legislation is what was retained EU law and is now assimilated law. So following the Retained EU Law Act, under its provisions, the status and the specific acts of primary and secondary law named in each of the common frameworks has changed, and UK ministers have been newly empowered to revise, revoke or restate those same pieces of legislation that are named in the common frameworks in terms of their scope. And they can do so with greater ease than they could previously. Moreover, UK government ministers can make amendments to assimilated law under the terms of the Retained EU Law Act in areas of devolved policy, with no corresponding obligation to obtain devolved consent, albeit there have been commitments not to do that, though they aren't statutory in nature. And I'm sure my colleagues will pick up on that, Anurag and Nick in particular. So while the Retained EU Law Act has changed the position of this category of law that was quite significant in underpinning the development of the common frameworks, you can also say on the reverse that these common frameworks are intergovernmental agreements. So they don't necessarily, they were never legally binding agreements. And so they can continue to operate, but that's sort of the theoretical position. But the big question that's brought in here is really the deregulatory preference of the Retained EU Law Act. because one of the principles underpinning the development of common frameworks was to allow for differentiation and devolved autonomy in policy making. And the Retained EU Law Act makes it difficult for legislators in Scotland, Wales, and Northern Ireland to opt to follow a higher standard, higher regulatory standard than is currently provided for in the legislation, because of the deregulatory preference if they're to use powers under the Act in order to do so. So that's sort of the tension that we're in understanding these interactions. I'll just briefly, am I okay for time? I've maybe got 1 minute left, Katie? 2 minutes left, perfect. So just to say something about the indirect impacts of the Retained EU Law Act in areas that we don't have a common framework developed for. However, they were identified in that initial mapping to say that this is an area where devolved competence and EU competence previously intersected. So 120 areas were identified, but deemed no framework required. And that's interesting because when we go back and look at the reasoning there for deciding whether or not frameworks were required, in some instances, this was due to the risk of divergence being thought to be minimal. Other areas, it was thought intergovernmental arrangements would be sufficient to manage the risk of divergence. And then in a smaller category of areas, it was thought that any divergence that would arise would be minimal in terms of impact. So with, again, the Retained EU Law Act bringing in the changes that it did, it has made it easier for UK ministers to make changes in areas of assimilated law within this category. Is included the 120 areas where no framework was required. So it's easier for divergence to now arise in these areas where it was deemed that there would be a minimal risk of divergence. And again, Retained EU law played a part in determining whether or not there was a risk of divergence or otherwise. And then similarly, the conclusion in, I believe it was 50 areas out of the 120 areas where intergovernmental arrangements were deemed sufficient to manage the risk of divergence. The fact of the Retained EU law bringing in the potential for changes to be made in areas of devolved law without devolved consent does just raise a question mark about that assumption of intergovernmental arrangements being sufficient at the time. Again, this is not to say that the Retained EU Law Act has completely done away with common frameworks or completely undermined the principles or purpose of them, but it has made the sort of foundation on which they were based and the assessments made at the time in the early stages are now more shaky than they were previously. I think I can maybe conclude with that and leave it to the next speaker. Thanks, Katy. Oh, I think you might be on mute, Katy. Oh, sorry.
Can you hear me now?
Yes.
Probably not very well, but I will speak loud. If you can't hear me, I'll try a different camera, etc. So I said, thank you for giving the time, and I suspect that shakiness will be something we return to in the other presentations too. So thanks, Lisa. Without further ado, we're going to turn now to the theme of devolved government's powers to change and replace assimilated law. And so speaking to this is Nicholas Kilford, who's a postdoctoral research associate in the Durham Law School, working on an open research area funded study on unwritten constitutional norms and principles. Also co-author with Anurag Deb, who's a PhD researcher at the School of Law in Queen's University Belfast, whose doctoral research focuses on the task of legislative drafting in the UK and understanding its values. Over to you both.
Thank you very much. I'm going to deal with some general summary points from our theme, and I'm going to take some specific illustrations of these points. As has already been outlined, the Rail Act sunset 587 instruments of retained EU law and assimilated all rail remaining on the statute book at the end of 2023 to be handled by the UK's various governments and legislatures. The Act intended to diffuse assimilated law within the legal system, remove its special status, and facilitate easier divergence from the EU. In order to do this, it empowers the devolved governments, so far as within devolved competence, as well as UK government ministers, to restate, revoke, and replace, and update secondary assimilated law. These powers are important because they're quite potent. They permit significant divergence, both within the UK and with the EU, and may erode regulatory standards. The devolved governments don't see these powers as the most appropriate way of handling assimilated law. They prefer to enact more accountable primary legislation or use powers in other legislation. They don't see the case for diverging from the EU for the sake of doing so, and have not set targets for how much assimilated law to remove or replace. They want to maintain high regulatory standards and broadly align with EU ones, so they've therefore not been particularly eager to exercise these powers. Our theme of the report identifies problems both with this suite of powers itself and with their potential exercise. Firstly, the framework itself is very complex and incohesive, undermining the Act's ambitions for lean regulation. For example, a restatement can use different words or concepts from the law being restated, can modify or reproduce an equivalent effect to the principle of supremacy, retain general principles, and directly effective EU rights, which the Act generally disapplies. A devolved authority can reproduce the effects of retained general principles and directly effective rights on their own without restating assimilated law, can reintroduce the interpretive effects of assimilated case law to restatements, even if the latter uses different concepts or words. And the devolved governments can ascribe priority to specific pieces of assimilated law over specific pieces of domestic law. The revocation and replacement powers can be put to broader purposes than are available for the restatement power, but the revocation and replacement powers cannot be used to increase the regulatory burden, an idea which we consider to be conceptually and practically problematic. Further, the powers are deregulatory and divergent in spirit. The framework does not account for which norms will be assimilated law and which will, in Northern Ireland, still apply as EU law. Their oversight and accountability mechanisms are limited, meaning their exercise is opaque and offers limited opportunities for civil society contribution. As Anurag will explain briefly, they also intersect with a range of limitations, restrictions, and frameworks that could make their effective exercise unclear, difficult, or legally tenuous. Our recommendations include potential reforms to these and future powers that better reflect the different dividing lines, devolved, reserved, EU, assimilated, should simplify the scheme or avoid making it more complex by, for instance, introducing new concepts, and should be more cooperative in their spirit, as well as having better accountability mechanisms. Finally, although we recognise that the powers may not be best suited to devolved policy goals, we can see a case for restating assimilated law because this would seize the initiative. It would remove it from the category of assimilated law and therefore insulate it against the UK government's exercise of these powers. It could also switch back on various things that the Rail Act otherwise switches off, and therefore align more closely with the EU than the UK government might. The updating power, which can track limited dynamic change, and the priority power may also suit these purposes, and the replacement power can keep the regulatory burden the same, but we would encourage caution given the complexity to which the exercise of these powers can give rise. I'll hand over to Anurag to take a few further issues.
Thanks, Nick. Hi, everyone. I'm just going to go into a few sort of specific examples of the powers under the Rail Act interacting with other kind of diverse regulatory frameworks and also applicable in the UK. The four problems that we see, as Nick already adverted, relate to these interactions. So institutional isolation and friction, inadequate accountability and scrutiny in terms of the use of these powers and the making of secondary legislation, the regulatory burden concept and the sheer complexity of the assimilated law regime. Specifically, there are two main areas of interaction or potential friction, one, of course, being the Withdrawal Agreement and the Windsor Framework, and the other being the Scottish Continuity Act. And the Continuity Act has the sort of opposite regulatory ethos to the Rail Act. As Lisa mentioned in the beginning, the regulatory ethos of the Rail Act is divergent, deregulatory for that matter. And in the Continuity Act, it is supposed to be sort of more convergent with EU standards and EU regulatory schemes. And the Windsor Framework, specific to Northern Ireland, maintains a body of EU law as EU law and not as the sort of UK copy and pasted equivalent, but as real EU law with a link to Luxembourg jurisdiction to determine its scope and obligations thereunder, and it binds the UK in respect of Northern Ireland. Now, this is not, strictly speaking, territorially limited to Northern Ireland, but it is it governs a range of matters, both reserved and transferred to Stormont. And since earlier this year, the whole implementation responsibility over the Windsor Framework has actually gone from the devolved administration at Stormont to the Northern Ireland Secretary. So the UK government is now responsible for implementing the Windsor Framework. Because of these changes, there's a live question as to capacity to understand where the continued supremacy of actual EU law under the Windsor Framework intersects with the deregulatory ethos of the Royal Act itself, and where the sort of gray area between assimilated law and genuine EU law or domestic law used to implement EU obligations exists. And the reason why this is a problem is because when using the Royal Act powers, delegated lawmakers must be very alive to the risk that if you accidentally cut across a genuine EU obligation, the UK itself may be in breach of its obligations under the Windsor Framework internationally and of course domestically. So that's one major issue, and it's still fairly early in the regime to understand the capacity of both the devolved and the central authorities to kind of navigate that sort of live wire. The overall recommendation that we do have, as Nick briefly touched on earlier, is what we call a coherent approach to the use of assimilated law powers. This entails respect for pluralism and regulatory ethos, and respect for particularly the devolved interests in maintaining an element of convergence with the EU regulation, innovation in the exercise of these powers, a holistic recognition of all of the different regulatory regimes that interact with the Royal Act. And it's important, very, very important in our opinion, that devolved autonomy isn't compromised in the exercise of the Royal Act powers. Instead, it is recognized that actually devolved autonomy can provide the impetus for innovation and the innovative use of these powers, and that regulatory pluralism is not a bad thing necessarily. And so we touch briefly on the lack of transparency and comparative lack of scrutiny or accountability in the use of these powers, in particular, the lack of explicit collaborative mandates within the Royal Act. And so a lot of it is left to non-statutory agreements or non-statutory commitments. An example we explore is between DEFRA and the Office of Environmental Protection in relation to reforming assimilated law, which we recommend as being a good approach. But again, I think we would favor a more explicit commitment. And also in terms of the regulatory burden, it's a problematic concept in and of itself. It entails a series of judgments which are not necessarily legal, but are very policy heavy. We look to a similar concept in the Law Reform and Regulation Act 2006, finding that its scrutiny regime is a lot more pronounced and a lot more explicit than the scrutiny regime under the Rail Act. But there isn't time, given the sunsetting of the powers under the Rail Act, to introduce a full LRRA-style regime. So again, we call for greater collaboration, greater transparency. And then finally, we look at the Product Regulation and Metrology Bill as a welcome answer to the deregulatory ethos, because the PRMB's purpose is to introduce a way to track evolving EU standards and EU regulations in specific areas. Although we do caution, the bill is currently in the Lords, we do caution that these powers should also be given to the devolved authorities, and that the UK government shouldn't simply take it upon itself to realise devolved wishes. So I think that's, yeah. Thanks.
Yeah, that's a perfect place to stop. Thank you, if you don't mind, and thank you for giving the time and setting things out so clearly. So without further ado, we're going on to the UK Internal Market Act. And presenting on this is Thomas Horsley, who's Professor of Constitutional Law at the University of Liverpool, specialising in constitutional and comparative law with a particular focus on the UK and EU legal systems. And then Dan Wincott is a Blackwell Law and Society Chair in Cardiff University School of Law and Politics, based in its Wales Governance Centre. Dan has directed the Economic and Social Research Council's Governance After Brexit research programme since 2018. Over to you both. Thank you.
Thank you, Katie, and good afternoon all. Our contribution to the report focuses on the UK Internal Market Act 2020, the UKIMA, or for some, the UKIM for short. There's not really much time to get into the weeds this afternoon, including, of course, the specifics of the Act's application in Northern Ireland. But instead, Dan and I would like to highlight some key points from our report. I'm going to start by discussing where we're at, and then my colleague Dan is going to reflect on things, where things may be heading, particularly, as Dan mentioned earlier, in light of last week's UK government announcement on a review of the UKIMA. So first, what is the UKIMA? Well, I'm sure you're aware of it. And in the first section of our report, we discuss the context, how we arrived at the UKIMA, the intersection with the common frameworks that Lisa mentioned in the opening paper, the position of the devolved governments in relation to the UKIMA, and of course its core provisions. But in short, the UKIMA is a legal solution to the challenges of managing regulatory difference within the UK post-Brexit. Now, this wasn't really much of an issue before Brexit because, of course, EU single market law provided us with a common set of regulatory standards. And of course, as we discuss in our report, the UKIMA isn't just about trade regulation. It also regulates other really important aspects, including the provision of new powers, spending powers for the UK government in devolved areas, which is also important and controversial and discussed in our report. But this afternoon, I wanted to highlight some of the things that we think civil society will be interested in knowing about the UKIMA. And there are really kind of two themes or two watchwords that bring together our assessments. The first is centralising or centralisation. And then the second is this idea of deregulation or deregulatory trends. So I'll say a few words on both with reference to our report. So first on centralisation, in very broad terms, civil society actors really should be alert, I'm sure you are already, but should be alert to the fact that UKIMA establishes important new powers for the UK government to effectively regulate, but also spend in devolved areas. These powers were created without the consent of the devolved institutions, and they really do significantly challenge devolved autonomy in very practical terms. It's also worth noting that the UKIMA positions the UK government as a sort of gatekeeper in relation to the management of the UK internal market generally. Brexit. And of course, the UK government retains effective control over the Act's modification, and Dan will pick up on that shortly. Secondly, we think in our report it's really key to note that structurally the UKIMA is a very deregulatory instrument, and this is particularly clear, of course, in relation to the regulation of domestic trade in goods and services post-Brexit. And in our report, we discuss the UKIMA and its introduction of these two market access principles that operate to regulate trade post-Brexit: mutual recognition, non-discrimination. And these, of course, commonly now known as the market access principles. And as you'll see in our full report, the UKIMA and its market access principles are really having significant practical effects on devolved policy making in really highly salient political areas such as environmental protection, animal welfare, and public health. And these market access principles, they really do bite. And we would refer you to sections 3 and 4 of our report to look at a couple of case studies which we unpack there. But there are three, I guess, for the devolves at least problematic, but in other words, just emerging impacts. Again, we expand on these in full, but I will just summarize them very briefly to conclude the remarks on the state of play. So the first, and perhaps most obviously, the UKIMA and its market access principles are sort of precluding the devolved governments from applying their regulatory preferences in devolved areas to products and services that enter their respective markets from other parts of the UK. Now, what does this mean? Well, it's a real challenge to the idea of devolution as a policy laboratory, and this is something we unpack in our report. Now, of course, if the devolved governments do wish to apply their preferences in devolved areas to incoming products and services from other parts of the UK, there is a mechanism to do so, an exclusions process, but it's very permissions-based. And again, this demonstrates that idea, the first theme, the watchword of centralisation. And as we discuss in our report, its practical application, this exclusions process, really has emerged as a source of political tension. The second broad thing that's worth recognising is that the UKIMA market access principles also prevent the devolved institutions from responding to regulatory changes in other parts of the UK. And this is really important. And in practical terms, it means responding to changes introduced by the UK government for England only. And we think this is really key for civil society actors to grasp. And we discuss the Genetic Technology Precision Breeding Act, that's UK legislation applying in England only, in section 4 of our report. And then thirdly, in terms of broad themes, we think civil society actors should be really aware of what appears to be an emerging trend towards four nations, or perhaps more accurately, nations and territories approach to policy making in devolved areas. What we're beginning to see is, rather than go it alone and struggle with the market access principles, there is some evidence that the devolved governments are increasingly moved, or some might say even pushed, towards reaching agreement on UK standards in devolved areas with the UK government and the other devolved governments. That, of course, has big implications for the directing of resources for civil society actors, in terms of even just lobbying and knowing where to direct scarce resources. And we discuss one example here, the tobacco and vapes regulation. This is a good example of this perhaps emerging trend. So there's lots more to say here, and I will refer you to the full report in detail, but I'm going to pass over to Dan, who's going to look ahead and reflect on the road ahead, some recommendations, especially following, as we say, that announcement from the UK government last week. Thank you.
Thanks very much, Thomas. So I just want to very quickly talk about the way we came to write this report and the moment at which the report is now landing. So we started writing this report before the last UK general election was called. And I think the initial intention was it would be published kind of as part of the run-up to the election before the campaign had really got started. Then an election was called very early compared to most people's expectations. And so we were looking at a report that would land just after the election. For a long time then, after the current Labour government was elected, it looked as if this area wasn't going to be a priority area on which the government at Westminster was looking to move rapidly. So we were kind of thinking of this work as we were coming up to this event as trying to generate some interest in the area, you know, an area made up of the retained EU law legislation, common frameworks, and UKIMA and their impacts on devolution that were kind of a legacy of a period often understood as a period of muscular unionism by UK Conservative-led governments that were, trying to reassert the power of the UK's centre. And then, even a couple of weeks ago, the Welsh government was announcing that it won't take part in a UK, ostensibly UK-wide deposit return scheme, which is one of these policy issues that has been very much affected by UK internal market legislation. And then last week, we have an announcement made by Douglas Alexander in the Commons and Baroness Jones of Whitchurch in the Lords, saying that common frameworks and the UK Internal Market Act will be subject to a very quick, a very rapid, immediate review process. So the Common Frameworks Review is supposed to be complete by Easter. There's supposed to be quite a wide-ranging review of UKIMA, not just the legislation itself, but also its operation by the summer, which is ahead of the timetabled schedule for reviewing UKIMA. Now, those review processes are are really urgent. They're matters on which we believe civil society organizations should be focusing their attention, reviews to which civil society organizations should be looking to make really significant contributions. And that's civil society organizations across the UK, but also in each part of the UK. So in Northern Ireland, in Wales, in Scotland, and in England, all need to be focusing attention on these review processes. I think particularly making sure that the voices of civil society across the UK are heard. That's really the crucial thing. The review process appears to be quite an open review process. There's a lot of emphasis on engaging with the devolved governments. So again, civil society in Scotland, Wales, and Northern Ireland can focus some attention, I imagine, on lobbying their devolved governments about what they want from the changes. But I think it's also important to focus directly on the UK government. And here it's interesting to me that it's Douglas Alexander that's leading this in the Commons, so being led from the Department of Business and Trade. Apparently, I'm sure the Duchy of Lancaster will be involved in the process, but it seems to be centred in another part of the government machinery. And from the Lords, it seems to be a focus on legislation, given Baroness Jones's remit. The issues that we're raising in this report are highly technical and very complex. This is one of the kind of, how shall I put it, one of the nerdiest reports that I've been involved in putting together, and I've been involved in some pretty nerdy reports in my time. But it is really important that civil society works together through the kind of framework of organizations that help structure civil society across the UK to grapple with these complex issues. Because in a lot of these areas, you'll find that there will be significant engagement from business organizations, for example, who may have an agenda that's partly about how the UK is organized in territorial and constitutional terms, but it's partly about their own direct business interests. And on the other side, you'll have people who are maybe trying to promote different standards or higher standards. That's not to say that business isn't always interested in low standards, or sometimes business lobbies very effectively for high standards. But on something like the deposit return system scheme, including glass in the scheme, focusing on reuse as well as recycling. These are issues that for some environmental organizations, for example, will be very important. And the opportunity for that kind of a lifting up of regulatory ambitions may fall if this opportunity to restructure, to review and restructure the common frameworks and UK internal market legislation isn't taken. I just conclude by saying, I think it's hard to overstate what a large set of constitutionally significant steps were taken with the retained EU law legislation, with the kind of moving in and out of focus of common frameworks, and with UKIMA. The UK government now seems to be putting a new emphasis on making common frameworks work effectively. That'll be a big, big task to achieve. They're very complex, as we've already heard. But also to reviewing UK Internal Market Act. And so this is a moment at which I think civil society really needs to focus its attention. And we have been, in that sense, extremely lucky to be launching this report just at a moment when a new phase of engagement is beginning because of a change of approach by the UK government. Thanks very much.
Thank you very much, Dan. It was very important that you were able to set the scene in terms of those two reviews that are happening. So thank you for doing that so well. And thank you, Thomas, too. There aren't as yet any questions in the Q&A. So please remember to post them there if you have any. And in the meantime, I will hand back to Lisa to talk about devolution and divergence. Thank you.
Great, thank you, Katy. And I will keep this snappy, conscious of time, and also it's kind of excellent to go last after everyone's made the really important points, and I can refer back to them. But the final contribution in the overall paper looks more specifically at the implications of EU exit for UK devolution broadly, and in particular underlining that new potential for intra-UK divergence that follows from the removing of the legal and policy frameworks that come with EU membership, which had effectively acted as a scaffolding for the evolution of policy in the different parts of the UK, in so much as it had constrained the degree of divergence or differentiation between the territories because of a shared obligation to implement EU laws. And that's sort of the context in which we've been discussing all of these issues. And this final paper runs through briefly the main strategies adopted in view of EU exit to manage new potential for divergence, including the EU Withdrawal Act 2018 and the consequential creation of retained EU law, then the Common Frameworks process, the UK Internal Market Act, and then later the Retained EU Law Act. The paper also gives a high-level overview of the potential scope for intra-UK divergence in policy terms, which can be useful to sort of substantiate some of the principles that we're discussing in terms of the shift in constitutional changes that have been brought in under all of these strategies. Reiterating some of the earlier points, it highlights questions raised around autonomy for devolved policymakers, and also the deregulatory preference of the Retained EU Law Act, and how that calls into question the possibility for policymakers in Scotland, Wales, Northern Ireland and England to elect to bring in higher standards of regulation in areas previously under EU competence, which are therefore in the realm of assimilated law. So that should all be now familiar at this point. Then just briefly, I'll run through what the paper also does is to look at the specific territorial constraints and opportunities in Scotland, Wales and Northern Ireland. I'll try and keep it brief for Scotland. It looks particularly at the interaction and challenges raised by the Retained EU Law Act, read alongside the Scottish Government commitment to stay aligned with EU law under its Continuity Act, and flags just the deregulatory preference of the Retained EU Law Act sitting in some tension with the Scottish Government's explicit intention to raise standards in line with EU regulatory changes, presuming EU developments do increase overall regulatory burdens in relevant areas within the language of the Retained EU Law Act. It also then again flags the ability of UK ministers to act in devolved areas. As we've stated, there's non-statutory commitments for the UK government not to exercise those powers, but as Nick and Anurag set out, there's a whole realm of complexity within the legislation, even in and of itself, and how that actually comes to life. And then less directly, I think for the Scottish Government to consider is any changes being made in assimilated law in even non-devolved areas that are UK-wide or GB-wide, acknowledging the Windsor framework there, does also have potential to raise questions or inform and determine decisions being taken in the Scottish context around EU alignment, because the trade-off between aligning with the EU and aligning with what's happening elsewhere in the UK will come down to market preferences as well as policy principle. So there is a potential for changes in assimilated law happening at the centre of the UK government to disincentivise Scottish alignment with EU laws if it would not be in the interest of Scottish traders. So just to flag, that's the specificity of that arrangement in Scotland. And also just to say that, and even saying all of that, there are valid assumptions that underpin the Scottish Government's alignment commitment, such that EU standards are deemed to be better than UK standards from the Scottish Government perspective in terms of their preference to align by default where appropriate within the context of devolved competence. But there is a question as we go on and politics changes in both Brussels and London about regulatory vision and choices being made in both contexts as to whether or not which which of UK standards and EU standards are higher, what type of UK standards are higher, and these questions, I guess there's not an inevitability to rate standards across the board, and decisions ought to be taken in context of the policy area and specific debates being taken forward in both London and Brussels. Then just quickly on Wales, it acknowledges the narrower scope of assimilated law that was intersecting with devolved competence in Wales just because of the devolved settlement that it has, but nonetheless in significant areas, and lack of support, of course, for the Retained EU Law Act. The Welsh Government has acknowledged their different attitude vis-a-vis the UK Government on the merits of otherwise of changing, revoking or reforming assimilated law, and states that Wales's priorities should be aligned with those of the EU. Again, there's a similar assumption around the EU as the good regulator, and that's not to undermine that assumption, but to just flag it as what it is, an assumption. But the Welsh Government has said they will use the Real Act powers in a proportionate and judicious manner, where it's to the benefit of Wales to do so. Reporting from both Scotland and Wales suggests that the UK Government have to date upheld their commitment to seek consent and inform devolved governments where they're going to act in areas of devolved competence under the Real Act. So that's notable. And then I will very quickly just say something on the Northern Ireland picture, which is, as ever, somewhat different. So Northern Ireland is a unique position, post-EU exit regulation under the Protocol on Ireland, Northern Ireland, now known as the Windsor Framework, which of course requires Northern Ireland to stay aligned with a specified list of EU laws, primarily relating to trade in goods. For the purposes of implementation of Windsor Framework in domestic law, that means general principles of EU law, including supremacy, continue to apply in Northern Ireland, as Anurag and Nick highlighted. CJEU retains jurisdiction in Northern Ireland to implement Windsor Framework applicable law. So therefore, the impact of the Retained EU Law Act has to be understood, read in the context of these obligations under the Windsor Framework that already stand for Northern Ireland. And in a sense, you can say in some respects, due to the implementation of the Windsor Framework in Northern Ireland, the Retained EU Law Act has a less direct regulatory significance than it does elsewhere in the UK, because changes introduced under the Act don't apply to those acts of essentially EU law that continue to have an effect in Northern Ireland under and according to the Windsor Framework. However, the Retained EU Law Act changes do fully apply in areas that are outside the scope of the Windsor Framework, and due to the deregulatory preference in the legislation and its explicit intent to move UK regulation away from EU regulation, the parallel application of the Retained EU Law Act begotten changes and Windsor Framework applicable laws in Northern Ireland can be expected to create complexities and potential challenges for Northern Ireland stakeholders and just the management of the Northern Ireland market, because you have these two regulatory regimes operating in parallel and simultaneously. Additionally, where changes are being made in Retained EU law, or now assimilated law, in areas outside the scope of the Windsor Framework applicable EU laws, but that have relevance on a north-south basis on the island of Ireland, that can be expected to raise additional challenges for Northern Ireland, and in particular, for example, in environmental governance would be a big area there, and even some sectors of services delivery and standards is significant there. So overall, I'll wrap up. So post-EU exit, UK devolution has to now operate in a newly complex environment. And partly that is just the logical and unavoidable consequence of removing scaffolding of EU law and policy that's heretofore limited the potential for intra-UK divergence. At the same time, strategies adopted by previous UK government administrations to manage the legal implementations of EU exit, I think it's fair to say that they've exacerbated the complexity that would have arisen organically and simultaneously damaged relations between devolved and central government in the manner of the implementation. I do think we've turned a corner in that regard, and the current UK government is very explicit in intending to reset relations between the governments of the UK. And as has been highlighted in particular by Dan, the announcement of the review of the UK Act and Common Frameworks, I think, is indicative of that intent to reset relations. And it's broadly a really positive development when we're discussing these complexities and the challenge of managing intra-UK policy developments. But it also does raise questions, and I would suggest, particularly in view of the paper we've launched today, about the interaction of these different elements. So if we're going to review the UK Act, we have to consider how it intersects with common frameworks and the Retained EU Law Act, and you can't ignore the ever-presence of Windsor Framework particularities in this picture. So with that, I think I'll close and maybe have a little bit of time for questions. Thanks, Katy.
Excellent. Thank you so much, Lisa. Well said. So we've got 2 questions in the chat. One slightly provocative, I think it's fair to say, from Gethin Rees, which is good to see, and another one from Kevin Hanratty. So I will just ask, we'll just see who wants to answer these questions. So the first from Gethin is, the Welsh Government's delay to the deposit return scheme suggests that lack of legal and policy capacity in devolved governments is a significant issue, whatever the legislative framework. Do panelists think that awareness of this will lead to a greater willingness in the devolved governments to seek or accept centralisation of regulatory powers to the UK? Who would like to take that one? Dan.
Thanks, Gethin. So I think you point to a really critical issue about devolved capacity, which I think is particularly acute in Wales. For those of you that aren't avid Wales watchers, I very much recommend the former Minister Lee Waters' new set of podcasts on Welsh Government, which are very causing a lot of debate here in Wales. But the last couple have been on the civil service and really highlighted this point about capacity and policy-making capacity. So I think that's a critical issue. I think actually it's a very important issue in relation to the operation of common frameworks, for example. Common frameworks are quite intensive, use administrative resources quite intensively across the different parts of the UK. So I think you're right that it's an issue in the area that you talk about, and particularly, you know, whatever the legislative framework. I suspect that we may see more attempts to kind of collaborate in the development of policy making. That's certainly something that Thomas and I found in our report, this kind of emergent sort of 4 nations, 4 territories kind of an approach. For me, though, there is something important about kind of fixing the legislative foundations for all of this, because you can make the current arrangements work more or less well, and it feels as if there is at the moment a kind of mood to try and improve the way that they operate, but they're basically structured by the underpinning legislative framework, and you know, I think attention needs to be paid to that, as well as the kind of practical governance, and the issues about policy and legislative capacity are well made, but I don't think they should distract our attention from sort of fixing the legislative foundations. And as Lisa's just said, that's fixing the legislative foundations in relation to UKIMA, but also in relation to rule, because of the way these things interact. I mean, also less my area of expertise, and I hesitate to say this with at least 3 of the 5 people on my screen at the moment, but also attending to Windsor framework aspects as well.
Thank you, Dan. And then finally, a question from Kevin Hanratty, which is about picking up on Dan's point about the community and voluntary sector being aware of these 2 reviews, and in terms of what hook or argument should be used to try and encourage their participation amongst everything else. So is it the loss of devolved autonomy, the lowering of standards, needing to recognise particularities of Northern Ireland in decision making, all of the above, or something else? So just like literally 2 minutes, if one or two of you want to say anything on this. Thomas?
Yeah, thank you. Excellent question. I would very, very briefly, I would say that, as Dan, to echo Dan, this is incredibly technical stuff. It's also very layered and intersecting, and it is very difficult. And to answer your question slightly differently, I might suggest that in our report, you'll see that there's quite a lot of case study examples and practical examples. And I think in terms of hooks, they might function perhaps as the sort of the triggers to drive interest, because as we mentioned, in the UKIMA context at least, there's some really politically salient stuff, and that extends to other areas of controversy, such as, you know, direct spending in devolved areas. So perhaps a more examples, practical led focus will be something that will help to engage civil society, because we do appreciate it is incredibly technical.
Thank you, Thomas. Lisa, did you want to come in too?
I would just sort of echoing that, say there is a real risk, I think, that the new system that we're operating under isn't really workable, because of the complexity and because of the way in which different elements intersect. And I think it's not that controversial to say that you wouldn't plan it this way if you were starting again. And so the risk in terms of not engaging with an effort to make it better, to reform it, is that we end up with a system that is just not effective, even when it has good aims. And you can query its aims, but even in where what it's trying to achieve, it's not designed, it's not sufficient to achieve those ends. And so we can reform it, and there are ways in which we could suggest, and we go into some details in the paper, and no doubt the review will pull those out more. But I think it's the operability of this broad system for lawmaking that affects all of us, that really is sort of on the table here. In terms of how we go forward. And in that respect, I might just very quickly flag that we did attempt to put together a sort of checklist in view of our research and analysis for policymakers or stakeholders to look at whether or not the area they're interested in intersects with any of these different elements, just as a starter for trying to answer the questions. So that would be, thanks.
Thank you, Lisa. So with less than a minute to go, I'd like to thank you all for your excellent presentations, for being so succinct, and which is a very complicated area, and just direct everybody to the Civil Society Alliance website where all the reports will be published. And to thank you all for attending, to thank Rosalind for organising it all, and to wish you the very best of luck in navigating it. So thank you, everybody. It's been an excellent event.